Do you actually have to answer the insurance adjuster who calls after your crash? No. And here are the only 3 things you should say instead, plus the one reflex word that quietly wrecks Colorado claims. She sounds friendly, she already knows your name, and she is not on your side. Here's what's actually happening on that call. Insurance companies train adjusters to sound warm, patient, and genuinely concerned because a friendly voice gets people talking. And people talking is exactly what the adjuster needs. Every claims adjuster in Colorado is handling dozens of files at once, and their entire job function, whether they'll say it out loud or not, is to close each file for as little money as the company can get away without paying. That's not a conspiracy theory. That's the actual performance metrics they're evaluated on. So when she calls sounding sympathetic, remember that sympathy and job function are 2 different things, and only one of them is steering that conversation. The first mistake happens in the first 30 seconds, and it's not even something people say on purpose. It's the reflex. I'm sorry. I probably wasn't paying attention. Or I'm okay. I think, or it happened so fast, it might have been partly my fault. In Colorado, we use a modified comparative negligence rule, which means if you're found 50% or more at fault, you can't recover anything at all, and even a smaller percentage of fault gets subtracted directly from your payout. So if a jury or an adjuster decides you are 20% responsible, your settlement drops by 20% automatically. I've had clients call me 2 weeks after an accident, still in a neck brace, telling me they apologized to the adjuster out of pure Colorado politeness, having no idea that single sentence was now sitting in the claims file as an admission. Never say sorry, never guess at fault, never speculate about what you could have done differently. You don't know yet, and neither does the adjuster. And that uncertainty should stay in your favor, not theirs. The second thing that quietly wrecks your claims is talking about your injuries before you actually know what they are. Adrenaline is a chemical, not a diagnosis. I've represented people who told an adjuster on day 1 that they felt fine, only to wake up 2 days later unable to turn their head because of a soft tissue injury that hadn't announced itself yet. That recorded "I feel fine" statement becomes Exhibit A for the insurance company's argument that your later treatment isn't related to the crash. The honest answer every single time is that you're still being evaluated, and you'll know more once a doctor has actually looked at you. That's not evasive. That's just true. And it protects you from your own body's delayed reaction. Have you ever gotten one of these calls and felt pressured to just answer the questions to get it over with? That instinct to be agreeable is completely normal. And it's exactly what the process is built to use against you. So here's what actually happens on that first call and what you're allowed to do differently. In Colorado, you are not required to give a recorded statement to the other driver's insurance company. Full stop. That request almost always comes wrapped in a friendly language, something like, "This is just standard procedure. It'll only take a few minutes." But a recorded statement locked in early, while you're still shaken up and don't know the extent of your injuries, is one of the most valuable tools an adjuster has. It gets played back later if your account of what happened evolves even slightly as more facts come out, which is normal after any crash, but gets treated by insurers as inconsistency. You can decline. You can say you're not comfortable giving a recorded statement until you've spoken with your attorney, and that sentence alone ends that part of the conversation. Here are the only 3 things you actually need to say when that call comes in. 1. Confirm the basic facts, the date, the location, and that a collision occurred. 2. State plainly that you're still being evaluated medically and don't know the extent of your injuries. 3. Let them know you'll follow up or have your attorney follow up with anything beyond that. That's the entire conversation. You don't need to explain how the crash happened in detail. You don't need to estimate your pain on a scale of 1 to 10, and you don't need to answer questions about your prior medical history on the spot. Those come later, if at all. With someone in your corner reviewing what's actually relevant, it's not just what you say on that call, it's what you sign afterward. Adjusters sometimes move fast to offer a quick settlement, sometimes within days of the crash. Before you've had an MRI, before you know if that a sore back is actually a herniated disc. In Colorado, once you sign a release and cash that check, the claim is closed permanently, even if you discover 6 weeks later that you need surgery. I've sat across from clients who took an early $4,000 offer because it felt like free money, then needed $15,000 in follow-up treatment they couldn't touch because the release they signed closed the door for good. A fast offer isn't generosity. It's a bet that you'll take less before you know what actually you lost. None of this means you're rude or combative on the phone. You can be perfectly polite because politeness costs you nothing. Precision is what protects you, not friendliness, and not friendliness withheld either. Answer what's factual. Decline what's speculative, and let your attorney handle the rest. That's true whether this was a fender bender on Academy Boulevard or a serious injury crash on I-25 through the Springs. The rule doesn't change based on how bad the wreck looked, and it doesn't change based on which insurance company is calling either. It applies just as much to your own insurer as it does to the other drivers, because even your own company has an incentive to close your claim for less than it's actually worth. One more thing worth knowing. There is no law requiring you to respond to that first call within any particular window. You can let it go to voicemail. You can call back the next day once you've actually seen a doctor and talked to someone who understands how these claims work in Colorado. The adjuster wants you to feel like the clock is ticking and you need to answer immediately. But the only real deadline that matters early on is getting properly evaluated for your injuries. Everything else can wait a day. If you're dealing with this call or you're bracing for it because the accident just happened, the single biggest mistake is thinking you have to fill every silence on the phone call. You don't. A pause isn't rude. A pause is you protecting a claim that might be worth a lot more than the first number anyone offers you. And knowing what that number should even be starts with understanding how case value actually gets calculated in Colorado, which is exactly what we break down in another video on this channel. If you've gotten that call already, or you're expecting it, drop a comment and tell me what they asked you, because a lot of people are surprised how specific those questions get. And if you want a clear answer on what your case might actually be worth before you talk to another adjuster, our contact information is in the description below.